Good afternoon. This is Marcia Waters. I am the Division Director for DORA's Division of Real Estate. Today is January 22nd and the time is 2 p.m. I will now call the meeting to order. Before I call roll, I would like to advise the task force and members of the public that while the Division of Real Estate has been tasked with leading this task force and ultimately the issuance of the task force's report, the views, opinions, and recommendations discussed and expressed by the task force are not the views, opinions, or recommendations of the Division of Real Estate or the Department of Regulatory Agencies. And with that, I will now call roll. Joe McConnell.
Here.
Dr. Davis. Natasha O'Flaherty.
Good afternoon. Here.
Brian Matisse.
Present.
Burton Adler.
Present.
Barry Wilson.
Present.
Representative Parenti.
Here.
Senator Gonzalez. Marianne McGeady.
Present.
Christopher Elliott.
Here.
Jennifer Tanaka.
Here.
And Steve Odoricio. Well, it definitely looks like we have a quorum. And with that, I'll turn that over to Sarah.
Wonderful. Thank you so much, Marcia. I'm just going to share my screen here with our slide deck. We'll get started. All right. Well, welcome, everyone. Thank you, Marcia, for introducing me. As you know, I am Sarah Reynolds, and I'm part of the facilitation team that is helping you run these meetings for the Metro District Task Force. So we're going to start our meeting, as we often do, with our meeting norms. This is just a reminder at the top of every meeting that these are essential for constructive discussion, and that we all have a responsibility to uphold them. So I'm not going to go through them in detail, but it's just nice to start our meeting with those reminders. Another reminder, not necessarily a norm, is that I will from time to time break into the conversation if there's questions that need a little clarification. For the purposes of the report, we want to make sure that all of the information that you are sharing is clear and well understood so that we have a high quality report. I wanted to also just talk about our agenda for the day. We have two main topics that we're going to be talking about. The majority of our meeting is going to be focused on the topic of governance, which includes voting and elections. And we will start the topic with an educational presentation from two speakers today. We have Mickey Mills with CEGR Law and Jeff Withers with the League of Women Voters Colorado. The second part and last part of our meeting will be reviewing the legislative recommendations that were provided by the HOA task force. As you know, this is a task force that is being concurrent to this process, and they have submitted a letter to Governor Polis and legislative leadership in December with 6 legislative policy considerations. A copy of that letter was provided in your pre-read materials last week. And as you know, HB 1105, per that legislation, this Metro District Task Force is required to review and consider how some of these recommendations may relate to some of the topics that we are discussing in this task force. So just a reminder on our two guest speakers today, we are providing these sessions to provide a shared foundational understanding of current practices and statutes. And so we've asked our guest speakers, who are subject matter experts, to come and support this work and deliver factual information, but not offer any personal opinions. So when we get into this, the discussion, that is your opportunity as a task force to debate and have a thorough conversation around this. But let's save that for task force discussion and not engage our presenters in that debate. The last thing I wanted to just mention before we dive into our content today is just an update on our facilitation process. We wanted to let you all know that we have a couple of changes to upcoming meetings. First, due to the President's Day holiday, we have moved our February 19th meeting to February 26th. So it's just going to be 1 week later, and that is going to be between 2 p.m. and 4 p.m., which is our normal meeting time. Also, at our January 8th meeting, the task force had requested that our meetings include some opportunity for public comment. So we've adjusted our plans based on this input, and we now have dedicated our February 26th meeting to public comment and task force reflection. So DORA's staff is going to be coordinating and overseeing that process and providing notice to the public with instructions for testimony. And certainly we'll share more information about this as it's finalized. And then lastly, as also noted in HB 1105, this task force is also required to review the final report of the HOA task force. And so this is in addition to the legislative recommendations that we're reviewing today. However, the HOA task force report will not be submitted until April 15th. So we will be hosting a 1-hour meeting of our task force on April 22nd for the sole purpose of reviewing and discussing that HOA final report. So with that, we will, with those administrative items out of the way, we're going to go ahead and jump into our first educational speaker. Each task force member certainly has varying levels of areas of expertise. So we're very grateful to have Mickey Mills with CEGR Law with us today. Mickey Mills has served as a paralegal for CEGR since 1988, following service to several other Colorado law firms since 1980. In addition to substantial work in all aspects of real estate, statutory compliance, inclusions, exclusions, district formations and dissolutions, and most other aspects of special district law, Mickey is also recognized throughout the state for her work in local government elections of all types and training of election officials. Mickey also served as a member of the Interjurisdictional Election Issues Committee and assists the Special District Association in the drafting and review of election legislation, including the current Colorado Local Government Election Code. Mickey is a frequent educational speaker and assists in election training webinars for both SDA and the Division of Local Government of the Department of Local Affairs. Mickey has provided the statewide election judge training and instruction manuals for SDA for the last 30 years. So with that, I will go ahead and turn this over to Mickey, and I am also going to advance her slide deck for her. So I will get that pulled up in just a moment for you, Mickey.
Wonderful. You can go
All
to
right.
the slide. That'd be great.
Excellent.
Cool. Good afternoon. Thank you for inviting me to speak regarding election governance for Metro districts. I think it is important to say that the election laws required to be followed by Metro districts are for all special districts. Districts are required to conduct all elections that are not coordinated with the county clerks under the Colorado Local Government Election Code and certain parts of the Special District Act. If there is a TABOR-related ballot issue on the ballot, we must comply with the election requirements set forth in TABOR. Next slide, please. To be qualified to serve on a special district board, including Metro districts, such person must be an eligible elector of that district. Next slide. All districts are required to conduct regular elections to elect those persons to the board to fill the positions whose terms will be expiring. That date is always the first Tuesday following the first Monday of May of odd-numbered years. After organization, districts may call special elections on those specific dates defined as a special election date. This would include the November election dates in both even-numbered and odd-numbered years. If the special election will be held on a November election date, a TABOR ballot issue can be submitted to the electors. Only ballot questions, which are non-TABOR related, can be submitted to the electors on the other special election dates. Next slide, please. Districts can only conduct a TABOR election on the November election dates or at their regular election. For court-ordered elections, the election date can be any Tuesday unless a TABOR ballot issue will be submitted to the electors. Then the court must order the election be conducted on either a November election date or on the regular election date. Next slide, please. Districts are able to conduct either a polling place or mail ballot election. A polling place election can only be conducted if there are no TABOR ballot issues, such as the Board of Director election. Most districts opt for the conduct of a polling place election because of the higher costs involved in a mail ballot election. A mail ballot election can be conducted for any election. If the election will be held on a November election date, that election must be either coordinated with the county clerk or conducted as an independent mail ballot election. A polling place election cannot be conducted on a November election date. Next slide, please. Every metro district is required to comply with certain election requirements for every regular election. They must adopt an election resolution and appoint a designated election official, provide the call for nominations, accept valid candidate nomination forms, proceed to conduct the election if there are more candidates than the positions to be filled, or proceed to cancel the election if there are no more candidates than the positions to be filled. Next slide, please. All districts have always been required to provide a call for nominations between 75 and 100 days prior to the regular election. New legislation expanded that requirement. For metro districts organized after January 1, 2000, the call for nominations must be emailed to each active registered elector as listed on the voter registration list provided by the county clerk. If an elector does not have an email address listed, then the call for nominations must be mailed to each household where a registered elector resides. Then they must also provide it by one of the other identified methods. Now, one of those methods is posting on the district's official website. Because of the new law that now requires all metro districts organized after January 1, 2000 establish and maintain an official website and requires that the call for nomination be posted on that website, this is usually the second method that is utilized. Next slide, please. A regular election can only be canceled if there are no more candidates than the positions to be filled and there are no ballot issues or questions being submitted to the electors. Notice of the cancellation of the election is then provided. If a regular election is canceled, the DEO will declare that the candidates were elected to the positions for which they were nominated. The newly elected directors' terms of office, however, do not commence until after the regular election date. So there will be a couple of months when the old board is still in office, since the election can be canceled as early as the 63rd day prior to the election. Next slide, please. In all mail ballot elections, ballots are required to be mailed to each elector whose eligibility could be determined at the time of mailing the ballots between 22 and 15 days prior to the election. If an elector does not automatically receive a ballot, they will be required to request a ballot. Thereafter, the DEO can confirm they are eligible before issuing that person a ballot. For polling place elections, if an elector cannot go to the polls on election day, they may request an absentee ballot. An elector may also request that they be added to the district's permanent absentee voters list. Thereafter, persons who are still eligible electors will automatically receive an absentee ballot for each polling place election conducted by that district. Next slide, please. There have been many changes to the law requiring metro districts to provide additional information to their residents and property owners. Specifically, all metro districts organized after January 1, 2000 are required to establish and maintain an official website. The law sets forth all of the documentation and information required to be posted on the website. The call for nomination and election results must be posted. Agenda notices for each meeting of a quorum of the board will also be posted at least 24 hours prior to each meeting. All districts must file annually a transparency notice, which must include the next regular election date, information on obtaining and filing candidate nomination forms, information on the procedure for an elector to become a permanent absentee voter, and the name and contact information for the DEO. This transparency notice is also posted on the district's website. For any district organized after July 1, 2000, an annual report must be filed. And any metro district organized after January 1, 2000, which has residential units within its boundaries, must conduct an annual meeting. Now, this gives the property owners and residents the opportunity to hear information and ask questions about that metro district. Next slide, please. In the 35 years I've been assisting with special district elections, I have found that similar problems and challenges emerge during most elections, but I'll touch on a few. Persons truly understanding and accepting who is eligible to vote in the election can create issues for property owners that do not reside within the district. In order to vote as a non-resident property owner, you must own the property in your natural person name, not a family or marital trust, corporation, etc. The reasoning is because the elector must be registered to vote in Colorado, and obviously a trust is not. In mail ballot elections, the DEO must determine who the eligible electors are for purposes of issuing and mailing ballots. For the non-resident property owners, we must confirm voter registration on the Secretary of State's statewide voter registration list. Now, this is difficult when we do not have the property owner's residential address. We only have the property owner's address as listed on the assessor records. This must be done before we can issue that person a ballot. As a result, if an eligible elector did not receive a ballot because their voter eligibility couldn't be determined, they must request a ballot. Now, some people do not accept this problem and would claim they were disenfranchised, but that is not the case. We just can't mail a ballot to someone we hope is eligible to vote. Miscommunication or persons providing wrong information is a big problem and challenge. This, of course, creates mistrust with the process and confidence that the election is being conducted in compliance with the law. This is so hard to manage and correct, especially now that social media is the platform where a large portion of people get their news and information. Districts will post election information on their website. That may include the candidate nomination forms, application for absentee ballot, and information on how to obtain and return the absentee ballot. Now, this turns into a challenge when there are electors that have no computer or an email or internet access. So providing these electors with the necessary information or forms they may need to complete and return becomes an issue. A big challenge for some districts is finding a person who is knowledgeable in conducting special district elections and who is willing to serve as the DEO. Many districts do not have staff and only work with consultants. Since it is imperative that the election be conducted properly, law firms and district management companies are typically engaged to handle all aspects of the district's election. This will ensure that it be done in accordance with all legal requirements. Since vote and mail ballots must be returned to the DEO or an election judge in a secure public location, it is difficult to find these locations within or even near district boundaries. Many districts do not have offices or any facilities to use as the physical drop-off location. The location and ballot box must be a secure place under the supervision of the DEO or an election judge. As a result, sometimes the only option is to have the return of the ballots be the office of the DEO. That way, the DEO or election judge can document the exact date and time when a ballot is received. The DEO or election judge must keep track every day how many ballots were received and from which electors. The DEO will try to make accommodations for the convenience of the electors, but the process of receiving the voted ballots in a manner that provides the security required and access by the election judges or DEO is imperative. Well, that's all I have. Thank you again for this opportunity. I hope that the information I've provided has given you a better understanding of Metro District elections.
All right. Well, thank you, Mickey. We have about 5 minutes left for task force members to ask questions and just find out more about some of the content that Mickey presented. So be happy to open it up to some Q&A now. All right, Marianne, I see your hand up. Please go ahead.
See if I take myself off mute. Hi, Mickey. Thank you for your presentation. Yeah, in your background, you've worked a lot with the Special District Association and the Division on training DEOs. Can you talk a little bit about how frequently those presentations are made and what training is provided and who attends those training seminars?
You know, this is lovely that you're asking this question now. We do DEO 101 training with SDA and DOLA, Joe McConnell. We do that usually starting the December prior to the May election and then through January and February, so we can provide them with information on what they need. They usually are attended by some district staff members, some board members to kind of get an idea of who they may need to appoint, because usually by then the DEOs may not be appointed yet, just to give them more education on what kind of person they would need to bring in. We have found, though, that a lot of DEOs will conduct elections and find that the process was not as pleasurable as they had anticipated and choose to never do it again. So what we've been working with SDA on doing is actually having, starting this year, doing some DEO training to try to educate more people who may have never done elections before, to start getting them training now and seeing if we can do recruitments.
Great. I see Jennifer, Jennifer Tanaka, your hand is raised. Go ahead.
Hi, Jennifer.
Hi, Mickey. How are you?
Good, how are you?
Good. Thank you so much for taking the time to put this all together for us. I have two questions for you. One is I wanted to, and I think I might have just forgotten my second one, but can you talk a little bit about coordinated elections and your experience with counties being willing to do a coordinated election? And then by the time you finish, maybe I'll think about what my other question was.
Well, just to educate who may not know, a coordinated election is only in November, and those are, as I had indicated in my presentation, if you're having an election in November, it either has to be coordinated with the county clerk or conducted as an independent mail ballot election. So in November, they're almost required to coordinate. I've definitely had some county clerks before that encourage, the districts not to be, just because they're not familiar with the whole process. But they are willing in November. They are not willing in any time other than November, like say the May elections or anything like that. But they definitely are willing in November, Tabor elections.
Thank you. And then I did remember my other question really quick. If you could talk about the obligations, fiduciary duties, et cetera, of a DEO, and if a DEO is not performing in accordance with the local government but election law, what would be the process if somebody discovered that they weren't properly performing their duties? Is there a set process that one would follow? How is that handled in those instances? And then a little bit going into some personal experience. I'm not sure if you're aware of how often in your experience you've seen that, knowing full well that that is also a little bit of an opinion, but just want to see if you've seen that happen very often.
Quite frankly, I have not seen it very often. It almost sounds like they're being negligent. Is that your kind of, thought, or that they are just not knowing what they're doing?
It might be one or the other, quite frankly.
Yeah. We really haven't had that many of situations where it's gotten that bad, except that we will step in and assist if it's our client. I have a feeling that most of them reach out to Joe McConnell and get direction on what to do. But we have definitely, do a lot of hand holding with our clients to ensure that they are, doing all the steps. And so really there isn't a statutory process that I can just identify on what to do.
Great, thank you, Mickey. We are almost at time, but I have two questions or two hands raised, so we'll keep it brief. So Commissioner Odoricio, would you like to go ahead?
Sure. I think I'd like to learn a little bit more about general accountability, saying that, yeah, we'll step in when we need to. Makes sense for the attorneys to do, but what I'm trying to figure out is what are the steps if somebody feels like maybe the designated election officer wasn't adequately checking the credentials to determine ownership of property. Also, I'd like to learn a little bit about the difference of whether you could be an elector who lives there as a residence versus ownership of property. It's my understanding you could either be partial ownership of real property or you could be ownership of real property. And some people in my community seem to think that just means you get to be an elector or even an elected official just by simply owning an iPad that you paid personal property tax on, business personal property tax on. So I haven't found any sort of consistent answer as to how this is supposed to be done. But the part I'm having to deal with my constituents is there's a difference between what they're distinguishing is between metro districts who vote and the only electors are the actual builders or the developers before anyone else moves in, is a different issue than what happens, let's say, for other special districts where it's an operational district providing services, and folks that are still property owners that don't live there, whether it's business or real property, are still able to vote. I'm confused. I mean, let's say you had 100 members that own 1% of a property. Are they all able to vote?
Okay, let me start with
Sorry.
answering the question, who's an eligible elector? And that's the reason why I included that definition in one of your slides, is so that you could see it. The definition of an eligible elector is the same for all special districts, whether it's a dirt metro district or, you know, a full operating district. You have to be registered to vote somewhere in Colorado, and you can be a resident. If you're not a resident, then you can be a non-resident property owner of taxable real or personal property. In all the years that I have requested the property owners list from the county assessor, real and personal, all the personal property is owned by businesses. Well, to be a non-resident property owner, you have to be a natural person. But although we still look at that personal property owners list. So if you own property in your personal name, because again, you have to be registered to vote, then you can vote and your spouse can vote. We, of course, don't know who the spouses are, so they can request a ballot. If you own property with a whole bunch of group of people, which we see that a lot in the communities that have second homes or resort communities, where they will have an investment property and there'll be a whole bunch of individual names on it. If they're registered to vote in Colorado, they all get to vote. And if they have renters living there who are registered to vote, they get to vote. So yeah, everybody, I mean, you could have 0.5%, and if you own that property and registered to vote, you get a vote. Now, part of the definition of an eligible elector also allows for a property owner who owns the property by virtue of a contract where they are obligated to pay taxes on the property, which is a little bit different than obviously how we would purchase our residential property. So and that's usually the case in the developer districts. That's how they own the property in their natural person name, because the developer itself would not be eligible if they just owned the property in totality. They have to have individual persons who are eligible electors to be able to serve on a board of directors, and also who are tax-paying electors and able to sign the petition for organization to get started with the district court on getting a district organized. So again, it's all the same definition for any kind of district.
I know we're running out of time. Just for that last piece. So you're telling me that you don't even have to be an owner. You could just be an employee of a company. And as long as you're contractually obligated to pay the taxes or a portion of the taxes for that owner, which would be a corporation, you're now able to vote.
Little bit more complicated than that is there is under that contract to convey this person the property where they are obligated to pay, there is a defined piece of property. And then they have an interest in that property by virtue of the contract. It's not the developer owning the property and they're paying the taxes for the developer. They're obligated to personally pay taxes on the defined piece of property.
Thank you.
All right, thank you, Mickey. That's a lot to unpack. Appreciate that. I know Brian and Natasha, you have your hands raised, so we will be hearing from our next speaker shortly, but hopefully we can keep it quick. So please, Brian, go ahead.
Yeah, my question is pretty quick, I think. This regards to polling place elections. You indicated that the individuals that would receive mailed ballots in polling place elections would be those individuals who requested absentee ballots or were on the district's permanent absentee voter list. Is that correct?
That's correct.
So the question, I guess, is following up on that. Wouldn't it be better, or would it be possible to go to the county's permanent absentee voter list, in which there would be a lot more people that would sign up for that, as opposed to the district's permanent absentee voter list, where very likely, perhaps no one would sign up especially.
Well, obviously, the absentee voter has to be an elector of that district. And so if we're getting the county-wide permanent absentee, which really, they really don't have that anymore, because all county clerks are required to do mail ballot elections. So there really isn't a permanent absentee voter list for counties anymore.
Okay, thank you.
Regardless if they did, we'd have to identify which of these people on this large list are only the electors for this little district.
All right, thank you, Mickey. All right, Natasha, your last question.
3, but they're really quick. I guess the
Okay.
first one, and I've seen these blow up. And I know one of your firms that also represents developers, you say on the option contract, it's the obligation to pay. Now, some law firms have argued tooth and nail that obligated to pay doesn't mean they actually pay. But then you have people with these option contracts that they don't have a taxable interest in the property. So does obligated to pay mean they actually pay the taxes?
You know, that's something that I can't opine on. I would, if I was asked that question outside of this arena, I would defer to an attorney to answer that question.
Yeah, I mean, I have to
Natasha-
say, from a homeowner perspective, I feel where that is some part of the statute that's really getting perverted here, that we have this dance of, well, obligated to pay doesn't mean they actually pay the taxes, or they claim they paid the taxes cash and there's no cash receipt. Which brings me to the second of 3 questions. Just to clarify, I understand that before there's actual eligible voters in a district, typically when it's still owned by the developer, that we need an option contract in order to qualify and have people on the board. But once there are eligible electors, and again, I've seen this blown up and watched the high power $900 an hour attorneys fight this tooth and nail, arguing that even though there are eligible electors, the option contract is a valid basis to qualify a candidate. That does not seem to me how the statute reads. I'd be curious on your take.
Well, if they are an eligible elector by virtue of that contract, then they're eligible to be a candidate to serve on the board, as well as any of the other eligible electors.
Even
So-
when there are already eligible electors, so they can be on the director's parcel with a 1/10 interest, allegedly paying taxes, and even though there's eligible electors, your position is that still qualifies them because the way I read the statute is, no, once you have eligible electors, you don't do the option contract.
Well, it would depend upon the term of the contract. Sometimes most all the time, there is a set term, and then that contract is, either closed or terminated. But if there are real residents or other property owners, then they're all eligible. I mean, they are all eligible electors. And it might be that, the regular election will be a true election with some of those original board members from the developer, as you want to, refer to them, and, property owners, residents. But until that contract is terminated, they're still eligible electors.
And I think that is a bitter pill for homeowners to swallow, because that does seem very artificial. Then my final question is a little bit from the last meeting, but when we talk about November elections, and the hardest thing for me as a homeowner was coming to terms that nobody thinks of voting in May. When I was on town council, we moved our elections to November because that's when most people think of voting. But if we could quickly address, you said Tabor matters have to be in the November election. And I'm watching this interesting trend that typically the developer-controlled board initially sets the authorized debt limits, and some of them are extraordinarily high. Here in our valley in Grand County, we had a developer issue over $1 billion of authorized but unissued debt on relatively small districts. So it's not clear to me, does one need a reverse Tabor, or does it automatically expire after 20 years? are we talking just the bond debt, or does all indebtedness authorized by that initial authorization die, or does that require reverse taper in November?
That's another question that I would say we would have to talk to an attorney about. Yeah, I wouldn't be able to opine on that. There's, different levels of consideration that that's definitely an attorney to answer that question.
It just seems to, again, highlight a workaround to the homeowner's detriment. They think that the authorized debt that they had no voice in voting, that was before they owned properties. It seems like some attorneys are parsing that to say, well, only the bond debt is expiring, but we can put other forms of indebtedness on the district. I don't think that's what the statute intended. And yeah, it's an interesting piece of the November election. So thank you for indulging my 3 questions.
You're welcome.
Yes, and Natasha, certainly we can discuss that more in our facilitated discussion, and then anything taxation related, we actually will be talking about our next session as well on taxation authority. With that, thank you, Mickey. A lot of content packed into that time. We are just a little off on our timing, but I think we can get back on track. So Mickey, again, thank you so much for joining us. It's my pleasure now to introduce our next speaker, who will be Jeff Withers. Jeff Withers has served 24 years in the Colorado Department of Local Affairs, developing local government technical assistance and research programs. He and his staff assisted local communities in adopting sound management policies in land use and capital planning, purchasing, budgeting, financial planning, elections, and intergovernmental relations. Mr. Withers was also the primary state contact for all local government implementation of the Taxpayer Bill of Rights, otherwise known as TABOR, which was passed by the voters in 1992. And he was the state authority on the local government financial implication of Governor Roy Romer's Smart Growth Initiative. He served as a legislative lobbyist for the Department of Local Affairs, and he was the staff director for the Colorado Commission on Taxation from 2000 to 2002 through the Office of Legislative Counsel. Since retiring from state service in 2003, Mr. Withers has been a principal in the firm Policy Research Associates, which provides technical assistance and research on state and local government projects. Today, Jeff is joining us as a volunteer for the League of Women Voters Colorado Legislative Action Committee as the leader of the local government team. So Jeff, thank you so much for joining us. I understand you have a slide deck, and I believe you will be advancing your slides yourself. Is that correct?
The microphone. Hold on a second.
There you go. Oh, you're on microphone now. Yes.
Should have been there before. Sorry.
Yes. Are you going to be sharing your slide deck, or do you need me to do that for you?
Yeah, I'm planning to do it. I hope I can.
Okay, great.
I got 4 hands going here, so. Well, thank you for the introduction. Thank you, Madam Chair, members of the task force, and facilitators. I'll be primarily focusing on governance policies. You've heard a lot about elections now. Since I think a lot of the election policies are in the statutes, but I'm going to be mentioning them as we go along. And have I shared the screen? Oh, wait a minute. I forgot that.
Not yet. We don't see it yet.
Okay. Then I have to find your pictures again. Okay, here we go.
And Jeff, I can certainly advance it for you. You can just tell me when to advance live it if that's easier.
Yeah, that's fine. I need to make the, here's, I can't get the full screen.
It's all right. I'll go ahead and share it for you. It's no trouble at all. It can be a challenge when, it feels like Hollywood Squares and everyone keeps moving around. So
I can't make
no problem.
Full screen view has the screen sharing button on it, and I can't.
Understood. There we go. We'll just get the slideshow running. All right. So we've got it. So Jeff, I'll go to your first slide, and you just tell me when you want me to advance the next one.
Okay. That's, as I said, I'll be mostly talking about governance policies. So this is slide 2. Now, when we talk about governance policies, we mean choices that land developers make in establishing and managing their districts, and also choices that general purpose local governments make in approving service plans. Developers are in business to maximize profit, not to maximize homeowners' rights. And generally, the more control that developers have over the every aspect of the development, the more they can profit. That's natural, I'm sure. And the policies I'll be discussing are those concerning three things: multiple districts, community authority boards, and oversight of metro districts. Next slide. The management districts and service districts are a result of having multiple districts. Both are metropolitan districts. The Special District Act makes no mention of management districts or service districts. These are designations that the developer has chosen as a matter of policy and that the county or the city has allowed also as policy. This slide also shows at the bottom the qualifications of voter in a special district. The third one will be my focus in a few minutes. That is a non-resident who has to pay property tax under a contract to purchase the property. That's a rephrasing of the statutory language. Next slide, please. The first choice that developers make in the process of writing a service plan is to designate one of the districts as a management district, which is often no bigger than a 10 by 10 foot parcel of land. The developer then finds 4 registered Colorado voters who are relatives, employees, or close friends to sign a contract to purchase a tiny piece of property in the management district at some time in the future, qualifying them to vote in the district and serve with the developer on the management district's board. With the management district board under the control of the developer in this way, it is forever in his control because it will never have residents. Next slide. The other districts in the development are each called a service district. The same, excuse me, 5 people on the board of the management district often serve as directors in each of the service districts. Although the Special District Act speaks in terms of a single district for each development, developers routinely create at least 2 districts for the same single residential project. We've seen as many as 20 in one project. Of the more than 4,700 local governments in Colorado, over half are metro districts today. And it's estimated that well over half of those are service districts that exist for the developer's convenience. While their boards are still under the developer's control, that is before the residents move in, the service districts each sign a contract with the management district agreeing to transfer all their revenue and bond proceeds to the management district for it to spend. Next slide. Another practice that has become popular with developers over the last decade is the establishment of a community authority board, or CAB, we call them. The Colorado Intergovernmental Relations Law allows 2 or more local governments to create a new separate political subdivision of the state by contract, to which they can delegate any or all of their powers except taxation and eminent domain. Next slide. A CAB is organized according to the terms of the contract, leaving a great deal more flexibility to the developer than another metro district would. For instance, it could have a board made up of 5 members from the management district board, which normally would be the entire board, and then 1 director each from each of the 4 service district boards, if they had 4, giving the developer permanent control over with a perpetual majority. Excuse me. Next slide, please. Excuse me, I got to go to the next slide too. This is a signature page of a CAB contract signed by the developer for the management district. If you can read the type, it's District 1, and also for each of the 6 service districts. There are 2 and 3 are on this slide. If you could go 1 more slide down, you can see there are 4, 5, 6, and 7. And you may notice that the signature under each one of those is the same. It is actually the developer who's the president of the board of all of those districts. Now, the goal of a CAB, or a management district, is to manage the revenue received by each of the service districts and eventually from the proceeds of the large bond issues that they incur. This is where the real money is. There is no good reason to go to all this trouble except to deny residents access to the decision-making, taxing, and spending process once they arrive in the service districts. There are 17 developer districts cabs in operation in Colorado today. Next slide. The statutes provide for a certain amount of oversight of metro districts. In practice, however, it's pretty light. Counties and municipalities were given new powers in 1991 to monitor the progress of their metro districts following a spate of metro district defaults and bankruptcies in 1989. We know from anecdotes that a few municipalities take this responsibility seriously. Next slide. This slide shows an excerpt from the City of Westminster's policies and procedures for special district formation. This city is opposed to the creation of metro districts for residential development for some good reasons. I'll just hit the highlights of 3 of them. The second one is metro districts pay significantly more property tax without any commensurate public benefit. Number 4 says residents may be surprised to find out that the price of their home did not include the price of streets and utilities. And number 5 is studies have shown that home prices are not lower in metro district projects. Next slide, please. As far as state oversight goes, the Municipal Bond Supervision Act, managed under the Securities Commissioner's Office, includes the registration of special district bonds, requiring that certain standards must be met. Over 33 years and almost 4,500 bond issues, every one has been found to be exempt from registration due to the multiple exemptions placed in that law. Therefore, they are also exempt from the commissioner's oversight. Next slide, please. A 2006 bill made it illegal to enter into a contract to purchase property only to qualify as a voter for a special district election. Exceptions in the law made it possible for the practice to continue unabated. Another example of failed oversight from good legislative intentions. These few highlights of governance policies have served land developers well, allowing them to retain control of their domain and avoid almost all interference from residents. We have heard from many residents that their metro district gave them incorrect information on how to vote in their district elections and or run for the boards that they're allowed to serve on. Whether this is on purpose or due to ignorance is irrelevant. The result is the same. Next slide. Developers are in business to make money. That's normal and expected. But controlling metro district revenues and bond proceeds help them make more. Some recent research has shown the average statewide return on investment in the land development business nationwide is between about 15 to 25% in each state study. Preliminary results of a study currently underway show the Colorado average may be well over 60%. Again, please note that all these policy decisions in metro districts are made in service of profit. The real money does not lie in the management of multiple metro districts, but instead in the bonds and other financial obligations. That's where the governance policies focusing on control are pointing. Then the last slide. The League of Women Voters of Colorado prepared a video with more detail on metro district governance and elections, which is in your meeting materials. It's about an hour long, and I recommend it to you. And I will thank you for your attention in this matter. I'll answer any questions that you have and that I can answer.
All right, we have about 5 minutes for some Q&A with Jeff. So we've got quite a few hands coming up, so appreciate that. And I believe I stopped screen sharing. Is that, can you all still see my screen?
I can see it, Sarah.
You can see it or can't? Okay, let me
can.
see. You can. All right, let me see if I can. There we go. Okay, thank you. Sorry about that. All right, I see lots of hands up. So how about we start with Brian? Go right ahead.
Thank you. Thank you, Mr. Withers, for your presentation. I want to ask a question about those management districts. I think you said that they're as small as 10 feet by 10 feet. I guess the question I have is, and maybe you've had some experience with this, the statute for creation of a service plan and the decisions on a service plan, that's CRS 321-203. That's the criteria for approval of a service plan. Are you familiar with that?
Yeah, somewhat.
Okay. The question I guess I have for you is, if a district is only like 10 feet by 10 feet and there can't be anyone that resides in it or any property that's served by it, how is it that these management districts can ever be approved because they wouldn't satisfy the requirements of 321-203?
I don't know what criteria in 203 would make them be any bigger.
Well, I mean, for example, one of the criteria is that there's a need for service in the district. If the district's only 10 feet by 10 feet, how could there be a need for services in the district?
Well, this is a matter of the oversight, I guess you might call it, that local governments have. County commissions and city councils have to approve the service plan, and then the presumption, I think, when they go to court for their organization election is that they have followed the statutes. So the judge orders an election and they're off and running.
Okay, and then just to follow up, in your experience with the Department of Local Affairs, have you ever seen a service plan be rejected by either a municipality or a county because it creates a management district where there's no need for services?
No, we never saw the rejected ones. They only sat in the ones that had gone through the whole process, and then they were a bona fide local government.
Okay, thank you.
Great, thanks, Brian. All right, Jennifer Tanaka, I see your hand is up next.
Yes, thanks, Jeff, for providing this analysis for us. I wanted to follow up on a couple of comments that you made regarding CAB structures. You had made a comment that the CAB structures are intended to essentially disenfranchise other voters by providing that control to the developers. I'm just wondering if you did an analysis of all of the authorities and regarding their voter membership, or whether you're basing this on a select few.
I haven't looked at all 17 of them, I must admit.
Okay. Have you looked at a majority of them, or has it just?
I think I've seen a majority of them, yes.
Okay. And then same with the comments regarding the purpose of the management and service districts, kind of tagging onto what Brian had talked about with the 10 by 10. You made the comment that management districts are set up on the 10 by 10. Have you done an analysis of all management districts to determine what?
Definitely not.
Okay, so it's just some that you may have seen that are of that smaller amount. Is that right?
I have seen some that are that way, yes.
Okay. And then you had a comment regarding developers making money off of the bonds. How familiar are you with IRS regulations regarding the use of public securities and how those are utilized by governmental entities?
Not familiar at all.
Okay. Okay. That's all I have right now. I might have a couple follow-ups if you don't mind.
Okay, thank you.
Thank you.
All right, thank you, Jennifer. And Chris Elliott, I see your hand is up next. Go ahead.
Thank you. Mr. Withers, I found your presentation interesting with regard to the governance issues. It seemed that to anyone who wasn't familiar with the governance process would presume that the ability to use authorities and multiple districts were in it for nefarious purposes. Frankly, I'm somewhat sad that in an effort to try and provide a description, an unbiased, objective description of how the governance process works, that the only conclusion that could be reached is that developers that choose to use those all have nefarious purposes. And to pile on to what Jennifer said, that those that do indeed engage in the creation of cabs and districts in general are there for the purpose of increasing profit margins. And then finally, I'm amazed at the study and would love to see a copy that suggests that those of my ilk and my competitors and compatriots are able to earn 60% profits as a result of being able to engage in this. Again, I'm quite disappointed that there wasn't an opportunity from an objective perspective to really look at some of the bright, shining, positive examples of how the governance process works and how transparent districts are and are obligated to be, and how there's plenty of examples, and I'd be willing to bet you a hamburger that we could find several that encourage the participation of residents as they become available. It's not my interest in owning, controlling, or otherwise having a fiefdom in a community and being in a position where I control a master district or a cab in some fashion forever. On the contrary, I try to get homeowners involved as early as possible. And I think that there are plenty of positive examples out there that could have been used.
Well, I didn't hear a question, but I just, as a conversation, I agree with you. I'm sure that there are. The problem with loose oversight is that the people who want to take advantage maybe of it make in some way they make everybody look bad. I mean, I didn't mean to overgeneralize. To tell you the truth, there's a lot of stuff in this little speech that I gave that is complicated, and this is just hitting the high points. Fitting it into 10 minutes is a challenge. So I talked too fast, and I didn't give enough caveats about how the fact is that there are very reputable people out there that are doing this business, and that they do include some, they look forward to people moving into their districts and encouraging them to be on the board. The financial arrangements between the management and service districts, when they are used for, I don't think, nefarious purposes, perfectly within the law, probably. But that's the kind of thing that the residents have been, well, I should say that's the kind of thing legislators have been hearing about, I think, from the residents, and the reason that we're all here today. However many there are, as I say, with 2,600 metro districts, I can't have a very intimate knowledge of very many of them.
Thank you, Jeff. All right, we've got a couple more hands that are raised. Mary Ann, I think I had you next.
Hey, Jeff, good to see you again. We haven't had a chance to talk in a while.
Long time, yeah.
Yeah, thank you for being here today. So I have a couple of questions for you. One is, to the best of your understanding, when a district is organized by a county, a city, or a town, what's its purpose? Why does a county, city, or a town organize a district?
Well, the statute says that there's a need for it, and that no one is filling it, I think,
Gotcha.
in general.
Yeah, and the need would normally be, what's the need?
Well, housing, I suppose, or commercial, or both.
Okay, or maybe I see your point. So it sounds like you're saying the county or city is trying to get to land uses that they want to see achieved, right? So they want a business park, or they want a retail center, or they want residential, or they want all of that. And to have that, they need roads, water, sewer, streets, maybe interchanges. Does that sound about right?
Yes, that's fair.
Okay, so let's say the development was a 4,000 acre development. How many districts do you think they should have organized to provide the water, sewer, interchanges, parks, 400 acres of parks, along that kind of magnitude? How many districts do you think they should organize to serve that?
I don't have an opinion on numbers. I think 20 is excessive, probably, but maybe not. I don't know. I just think that it's a phenomenon that doesn't get discussed very much. So that's why I wanted to bring it up.
No, I appreciate that. I'm just trying to understand a little bit in the context of those bigger master plan communities, how the objective of the city or the county or town that had that land use goal could be met if there weren't multiple districts, which is, kind of what we see. So we see the same thing you see, only with a different perspective. Because when I see those multiple districts, what I see is a city, a county or town and a developer trying to figure out how to finance, construct and complete developments. Some of them are smaller and some of them are very large. And the larger the larger the area to be served, the more districts you might see. The other question I have is, under those authority structures, I might have misunderstood what you said, but I thought what you were saying was that the authority structure is used to keep the resident voices out. I'm paraphrasing now. Is that what you intended to communicate, that the authorities are there to keep residents away from the board?
It's difficult to see any other practical purpose for them, frankly.
Okay, because when I read the authority agreements, and I often draft them, the purpose is to make sure that each of those districts that kind of line up with phases of residential development and commercial development as it progresses. In my example, through a 4,000 acre project, hypothetical project, you would then, as that build out happened, that district would have a representative on that authority board. So you're right, in the beginning where there's no one there, it would be all developer nominees on that authority board. And then over time, you'd start getting those other resident representatives and other commercial property representatives. And then when you get closer to build out, the developer nominees would drop back. And so you would then have a majority of everybody else on the board other than the developer, but the county and city and town goal would be met, right? The complete build out of the infrastructure to support the vertical land uses that they had tried to achieve. Does that make sense, what I'm saying?
Yes, I
You
understand.
agree with it, but I'm saying, does it make sense what I'm saying?
Sure. If you look at that slide from Westminster's, that excerpt from Westminster's policy statement, there is the opening sentence in it talks about how all of the development that's been done in Westminster in the past has not needed metro districts. And they don't think that anyone was ill-served by that. I'm kind of paraphrasing. I don't have it in front of me, but
Sure.
They seemed to think that there was no need for them in most residential developments. And then the last thing in that policy statement says that there are certain situations that may come up where a multiple district approach might make sense.
Sure. And are you familiar with the Uplands development?
No, I'm not.
Yeah, and that's a development in Westminster where the city did recently approve the organization of multiple districts for a residential community so that they could achieve the land uses that they were looking for and have the infrastructure finance that was needed to support it. So understand that's what their policy says, but it's not what they most recently approved.
Yes, thank you.
Yeah, thank you, Jeff. And we need to talk about DEO services. I left your message a while back. So when you have a chance, let's talk about it.
Okay.
I just, like Mickey was referring to, we're always looking for more DEOs. I wanted to brainstorm with you about how to get some.
Oh, okay.
All right, thank you, Mary Ann. Thank you, Jeff. All right, I see two more hands raised and I want to give you a chance to speak, but we are running a little short on time. So Pinky promised that you'll try to keep it brief so that we can make sure we have enough time for our discussion. Jennifer, I'll have you go next.
All right, thanks, Sarah. I appreciate it. And Jeff, I just wanted to pick your brain a little bit on, you made a comment about Westminster not needing districts in the past. How familiar are you with really kind of the resurgence or the surgence of districts and the correlation with Tabor? Have you had much experience there for?
Well, yeah, in fact, in the Colorado Lawyer, is that the magazine from the Bar Association, had an article in it right as soon as Tabor passed that the prediction was that there would be many more districts made because cities and counties wouldn't be able to finance improvements. And I don't know that that's, in fact, the legislature amended all the improvement district laws, I think, in response to Tabor around the same time in 92, 93, something in there, to make them work better for cities and counties because they thought that might be a method that would serve them. But I don't know that there's been any increase in the uses of them, to tell you the truth.
Okay. And then kind of on the same lines on that. And I'm not sure if this goes outside of your area expertise, just let me know. But how familiar are you with the use of districts for infill projects in pretty much fully developed cities like city and county of Denver, where you have just little pockets anymore versus those are sprawling out more like Aurora? Are you seeing a correlation there between the use of districts in one or the other?
Well, Denver's a good example. They have one out at Loretta Heights, and the same folks proposed one in City Park, and it got voted down by where the conservation easement got saved, I guess, by the voters. But that's the only real infill one I know of offhand. The whole tech center was done with metro districts, and that was back in the day when I don't think there were management and service districts there, but I could be wrong. And of course, the airport is where, after the tech center was built, I understand I was told by somebody at the division of or the planning department in Denver that Denver was never going to have metro districts again. And then when the airport started up, then there they were again. So, things change.
Yeah, for sure. Okay, I just wanted to see, I think we see them traditionally a lot in some of the more sprawling areas that are newer, that don't have if infrastructure out there, and of course some of the pocket areas that are in need of updating of infrastructure or expansion of those, oversizing of infrastructure to suit the needs of something like Park Hill, which was approved by the city and county of Denver. It was a city vote that was separate.
Yes, that's right.
With the conservation easement that did not pass the citywide vote, but the service plans were approved by the city and county of Denver for that project.
That's right.
I just wanted to, I know we're on a limited time, so I want to make sure that we get to Natasha's too.
Okay.
All right. Natasha, bring us home with your final question.
Actually have 5 of them. We'll do them
No.
rapid. First, let me say, Jeff, thank you. It's refreshing to have a speaker who's not employed or beholden to developer interests. I think it's important that we have more perspectives in this dialogue. And I was newer to this, and I know, Marianne, early you helped me point in the right direction where to start reading and learning about this 2 decades ago. But when we talk about the idea of option contracts, you were talking about these, new terms that aren't in the statute of a control district. I mean, really, isn't it the intent of the statute that if I was just about to close on my house or had an option, that obviously I have a taxable interest? Is that your understanding of the statute, as one has a taxable interest? That, yeah, I'm going to be paying taxes in this district, ergo I am entitled to vote. Is that your understanding of the statute? Well,
Certainly that is one situation where they serve a practical purpose for everybody, I guess. But I think that small little subsection, if that's the right word for it, in the statute, I think was put in 1970 when Tom Grimshaw was in the legislature. And I don't know what particular situations he was or they were thinking of when it was put into the statute, but I would say that's sort of an outlier. I mean, I can't imagine anybody would be so have a burning need to vote in an election of a metro district that they probably hadn't even heard of right before they were going to close. It seems awfully coincidental to me, but if that ever happened, that would be a good reason to have that in the statute, I think.
Yeah, I mean, I agree with you. I mean, it does seem artificial, and it does seem, unfortunately, the practices are. And then the cab is newer to me. I was just reading a document of one. When you say it's perpetual, how does it get around the 1-year limitation of a metro district? The contractual obligations can be terminated after a year. When you say a cab is perpetual, how do they get around that 1-year limitation?
Well, I don't think that they have any obligations of their own. They receive the money from the other ones. The metro districts have the obligation of their own. And I think that, I'm not sure exactly about all the practice, of course, it's impossible almost to know, but I think that in the management service district relationship, the contracts are approved at an election. before the residents move in, typically. And so they can have the force of a general obligation, I suppose you might say. I'm not even close to being a bond counsel, but I think it's sort of like that. And I think that is the few that I've seen, I guess I should say, have looked like they were done that way.
Thank you. And then speaking of bonds, I mean, when we have these control districts and management districts, we talk about bonds, but there can be bonds issued to the developer. There can be other types of fees and loans, correct?
Yes, TABOR refers to multiple fiscal year financial obligations. That's the kind of magic word that the TABOR elections kick in for. And so those would be elections that to approve a contract like that's not a bond issue, would have to be done in November, as Mickey was saying.
Okay, and then my final question, and Mary Ann hit on this one of, why things are organized. I live in a small town, so it's kind of interesting. I live on this side in a metro district. Across the street development exists without a metro district. I appreciate your observation that it seems like development. When Ms. McGeady asked about, well, why are they organized? I was quite perturbed to find out that sometimes it seems it's very self-serving. In the town where I reside, the town gets 10% of all bond proceeds that are issued.
Oh.
Is that a situation that you've seen in others as well, that there seems to be financial incentive for towns and counties to approve these metro districts? I mean, the district I live in was rejected by the county. They said it was financially not feasible. It was then approved by the town, and there's this financial incentive for a town to approve it.
Yeah. Well, that happens in not just money. Rock Creek Ranch was annexed to Superior so that they could have their development in a city, and the deal was that they would improve the water system up there. And so the town of Superior annexed a huge, I mean, I don't know what the ratio was, but it made Superior being a huge place compared to what they were before. And that was quite a few years ago. But I mean, there are different kinds of incentives, I guess, that can be used. I don't know all of them, obviously.
Thank you for sharing your perspective again. And
sure.
One wishes that all the towns were as well-versed, Mary Ann, as the ones you say, but I admit it does seem in communities where there's a lack of understanding of what a metro district is and how it functions among a county or a town board, the risk of where things run amok is very high. So I'll turn it over to Mary Ann and Jennifer.
All right, so we are running very short on time. Mary Ann, I know that there were a couple of comments to some of the statements that you had made, so I would like to give you a chance just to clarify perhaps what you were saying, but we do need to make sure that we have time for our facilitated debate. So just ask that you try to keep it brief so that we can transition to our discussion time.
It's hard with a topic this complicated.
It is very, yes, agreed. It's very complex.
I put my hand up to say something, but now I'm going to say something else. The Rock Creek Ranch situation was a district where there was a management district, coordinating district, and 2 taxing districts. One of the reasons for that was that the management district was expanding the water sewer system to take those 150 houses that were below the poverty level and get them proper water and sewer service. You're right, Jeff. And then the intent was when build out occurred, the transition would happen of the water sewer system and that district over to the town of Superior. So the town of Superior continues to do that. They did not want a subset of the town to run the water sewer. So I guess the reason I bring that up is to say there's many different reasons for these structures and they solve different purposes, but they are not developer imposed. Developers come in and request land use approvals, and then they are handed over a list of public improvements that are needed. And Natasha, you're right. Sometimes a list of public improvements goes to what's over here that the town needs, that the deficit's going to get even greater for when this new development occurs. And so you'll see a regional facilities component or revenue share between those new districts and the existing town. There's nothing nefarious behind that. It's about making sure that the public improvements can be there for the public, not just of the residents of that community, but the impact that it has on the overall community. But coming back to the governance structure, I believe the intent of these structures is not for developers to make more money than they're supposed to make. The intent of these structures is to assure the land use approval that was given by the city, county, and town, together with the public financing package that needed to be fulfilled from beginning to end, gets continued. And what we have seen recently, and I don't know if you're familiar, Jeff, with the litigation that's been going on, but it has the fear that you won't be able to finish the financing for a project is now starting to be realized when residents are coming on boards and starting to challenge the next financing. And so the point again of having one community be represented by multiple districts that have agreements, and I think the authority is a good structure to balance the need to get residents on the board, to see what the developers are doing, to challenge what the developers are doing and be part of the decision making. And the authority board allows that to happen, yet it also balances and makes sure the financing gets completed. Right. So I appreciate your comments on it. And I think we can always look at those statutes and make sure the transparency, accountability, and best practices are there. And we will continue to do that and have that conversation. But to not have the ability to balance the needs that are, again, the land use needs that the county, city, and town are trying to get approved and facilitated so that it's not just on paper, but that it actually gets financed, built, and comes to life. It's a tough thing to balance. And that's what these structures are doing. So thank you.
Yes.
All right. Thank you, Mary Ann. And we're going to go ahead and wrap up this portion of our conversation. So I will just ask our speakers to go ahead and sign off. You're welcome to watch the remainder of our discussion via our live stream. Representative Parenti, I believe I saw your hand come up. Did you have a question before we transition into the
Getting in the
conversation?
queue for the next stage, Sarah. Thank you.
Understood. All right, you're there. You're in the queue. Excellent. So again, just want to thank our speakers for being part of this and providing this education. I realize that in our debate, some were offering some opinions, and that is just kind of a natural outcome when we have a debate going back and forth. But it was, we did ask all of our speakers to maintain just factual information and not express too many opinions. So, but understand that sometimes happens when you have a debate amongst thoughtful folks like yourself who care about this issue. So with that, now is the time for us to go into that debate portion. And so Jeff and Mickey, thank you for being here. You can go ahead and sign off. Thank you. And this is your time where you can ask all kinds of express all kinds of opinions and offer debate. So so with that, we do have our discussion broken into 3 components: what is working well, what is not working well, and specific recommendations for improvement. And this is for meeting this requirement of our final report that is going to be discussing this topic and making those recommendations. So I think we have covered quite a bit and at least have brought a number of issues to the surface. So I am going to start with the what is working well component of what we've heard today. So Representative Parenti, do you want to go first or do you want to hold off till the next discussion questions?
Let me go ahead and hold off because I think
Sounds
it's under a different category.
Understood. And we can kind of take it as we come. If we do not need the full amount of time to discuss each of these in order, that is totally fine. So Mary Ann, I see your hand is up. So what is working well?
Okay, and if I could answer, Steve had a question, Commissioner Adricio, that wasn't addressed about taxable personal property. And I'd say my experience is a little bit different than what Jennifer referred to. I have had commercial districts where individual owners of taxable personal property have been qualified to be on boards because of that. I've had dentists get on the board, small restaurant owners and other small business owners who do own that property that they derive income from and therefore is taxable, be qualified to serve on boards. Just so, because I think sometimes people have the impression that commercial districts are all controlled by developers for all time, and that is not necessarily the case. So I guess what I want to say is I think that the statutes are working well, but I will have comments in the how they could be better. But I do, so I want to hold a point there. But I do think it is a tough balance, particularly where we are in history right now, where we want to be sure that residents have voices and other property owners have voices in projects and on the board and leadership of projects. At the same time, having the developers be able to assure for the approved zoning that they have and the land use approvals that they have, and the vision that the towns and cities and counties approve when they approve those developments and they approve those metro districts, that they're fully realized the way. And the guardrails that are in the service plans, I think, do work well. And I think with the recent statute that was passed, increasing those guardrails that were best practices in a lot of jurisdictions and now requiring them in all jurisdictions, I think are there that would be clear what developers can and can't do when they're working with districts and what districts can and can't do through authorities when they work with developers. I think also the disclosures have been improved and increased, and I think those make it a beneficial structure for everyone. I think the transition over time is important, but I think having transition occur with a district when the financing's not completed and the construction's not completed, and having the first set of residents or second set of residents be able to stop the financing for the rest of the project is giving land use control to people that are not supposed to have the land use control. It's supposed to be the city, county, and the towns. Yeah, that's all I have to say right now. Sorry, thank you.
All right, thank you, Marianne. All right, what is working well? Jennifer, I've got your hand next.
All right, thanks, Sarah. We had two components to this. We had the elections and then the governance. So on the elections part, I do feel that things are going well. It's highly regulated by the statute. We're subject to the same laws as other local governments. We did touch upon, I'd asked a question regarding enforcement of those who aren't performing, and there are means for that. It involves the Secretary of State's office. There are election fraud charges that can be brought against people if they are not performing their duties appropriately. So I think it is important to note that there are very strong penalties for those who are not participating in the process appropriately. That goes not only for DEOs, but also those who are voting, should they have any issues there, that those can be brought. I've actually had to get the Secretary of State's office involved in one of my districts where we had some campaign violations. And so there are means out there to handle some of those issues. With regard to the governance, I think it's important. Something that wasn't really talked about earlier is the voice of those that are impacted by districts. And one of those categories of people that are impacted are property owners and taxpayers. Maybe they don't live in the district, but they are impacted by decisions that are made by the districts, by the cities, by the towns, and having a voice for them, I think, is important. That's where you see some of the qualifications as far as eligible electors to allow them to have that voice. And in the beginning, there are instances where you have the developer that's the only taxpayer out there. So of course they are the most impacted by those decisions. And they are also impacted on the ability to sell any of that property based upon those decisions. So, I think that it's lost sometimes in the discussion that developers will make decisions because they're just greedy and they want to have these big, amazing profits that were reported that we haven't seen actual data on. But I think that the reality is that they also cannot sell lots if they are overburdened. And so there is a balance there that is self-regulating in many ways. Because if you overburden a property, you're not going to have somebody come in and purchase that property. There are also many regulations in place by the IRS as far as how bond monies can be spent. They have to be spent on appropriate public improvements. This isn't a slush fund for anybody, but they have to be properly used. That's highly regulated. That's a whole nother deep dive I think that we're heading into in our next task force meeting when we talk about taxation. So I'm going to save some of my comments there. I also think that there has been a lot of evolution of structures over the years. We've seen, particularly in the multiple district structure, there was what many refer to as using what is now very inappropriate language as far as the master slave structure. That is a very old, antiquated structure that is really not used, that has been evolved over time to where you have more of an operating financing structure, and you have abilities for those districts to detach from that structure over time. You have the ability of them to engage their own consultants, those types of things. I think there is a lot of information there on the evolution over the last 30 years that should be understood and appreciated when we're going through this exercise, so that we're not throwing the baby out with the bathwater. And I think those were the highlights that I noted. I'm sure I'll have some more later, but I just wanted to make a couple of those comments initially.
All right, thank you, Jennifer. All right, so still on the topic of what's working well, I see Natasha's hand up.
Oh, thanks. I was actually going to take it down. I do agree that the better notice, the website posting, I think it's where we're seeing more homeowner involvement. I think the media has been tremendous. Again, I don't think most people in America think of there's an election in May. We think of elections in November. So I do like that. I do think the disclosures are getting better. I still disagree per one of our early meetings that, you may be in a metro district now. Let's find out which one you're in and give more specific. So I think those notices, as the others have said, and the media attention have brought more homeowner involvement. And I'm not sure when you create a municipal entity, I'm not sure, and maybe Mary Ann can later touch, that we're not supposed to have land use control in homeowners' hands. If we are going to create a metro district, which is a taxpayer-supported district, the day to have homeowners on the board is the day there are homeowners and it's created. So that's what's working. And I think, Jennifer's correct. I think there's been an evolution. There has been some improvement as some of the issues have come to light.
All right, thank you. Appreciate that. And Brian, I see your hand was next. Please go ahead. What is working well?
Thank you. I think a couple things are working well. First, I think the legislative changes that have required better notification of elections, such as the call for nominations, not just being published in a newspaper, but actually being posted on the websites and or being mailed to the homeowners. I think that has resulted in a lot more homeowner interest and knowledge of these elections. That's working well, and I applaud the legislature for doing that. Also, I think what's working well is when you have a single district or a single neighborhood where the homeowners truly can elect representatives that will be responsible for that district, basically the nature of American democracy, that works well. In other words, where you have, like, I live in Tollgate Crossing, we have one district for the neighborhood. We have a homeowner controlled board that is elected, and they make the decisions, including the bonding decisions, including the development decisions, including the funding. That works quite well.
Great, thank you, Brian. And Representative Parenti, please go ahead.
Yes, just to add to that conversation, I've recently learned about at least a couple of towns in Colorado who have started taking on the practice of letting their city and town councils, or not letting, but having their city and town councils be the metro district boards for new metro districts going in. I think I would highlight that as a best practice. It ensures that there's always neutral folks who, again, are responsive to their constituents through local elections that can't be altered in some of the ways that we know special districts can be from the information we've received today. So I would highlight that. I also just wanted to make a general comment that, I think we've seen that this is a topic of a lot of interest, which is great. That's certainly to be expected. And I know that we're running short on time and that there's two other topics of our debate and another piece on our agenda. I would love to not see this conversation cut short, but rather, given the fact that we've got, going until April now, at least because of our final report requirement, that we give additional time for this conversation to go instead of cutting it short. That's all. Thank you.
Yes, and actually I was going to suggest the same. We do have the option of deferring the HOA topic for the next session, because I agree we want to make sure that we're giving this topic the time and attention it needs. And I know a lot of folks have things that they need to share. So appreciate that, Representative. And we will just go ahead and probably defer that topic so that we can use the rest of our time today to really explore this and make sure everyone has an opportunity to speak. So we will work with the team at DORA to make sure that we adjust those agendas accordingly so that we can handle that way. All right, so again, just to remind everyone that the more detailed you can be on your specific statements, the better for the report, so that we can be really clear on what some of those, especially those suggestions for improvement, might look like. So we're going to go ahead and move to our next discussion, and I think we can give this about 12 minutes to talk about what's not working well. And I know some of this has already come up in our conversation. So again, I would just ask everyone to try to summarize perhaps some of the points that you've made previously, or piggyback of what others have said, so we can make sure that we get to all of the content in an efficient manner. So who would like to go first on what is not working well? All right, Brian, jumping right in. Thank you. Go right ahead.
Thank you. I think what's not working well is, first of all of the legislative changes that were intended to promote better elections, better citizen involvement, more transparency, has all been in recent years undone by the advent of these community authority boards. Because what happens is now it doesn't matter at all whether the homeowners are on their board or not, because the community authority boards are always going to be controlled by the developers. Give you an example: Sky Ranch Community Authority Board, the developer district gets 5 votes. There's 1 vote to the homeowner district. Prairie Point, District 3, the developer district gets 3 votes. District 1 and 2 get 1 vote each. Pioneer Metro District, the developer district gets 7 votes. The 6 other homeowner districts each get 1 vote. Jones District, developer district gets 5 votes. Other 4 districts get 1 vote. Aurora Highlands, developer district gets 7 votes. Other districts get 1 vote. So it doesn't really matter anymore if you elect homeowners to the boards or not, if that's going to happen. The second thing that doesn't work well is when there's these type of structures where I have no problem with one discrete area, one discrete district. And if it's a multiple, if it's a huge 4,000 home area, break it into districts that have geographical areas. What happens instead, though, is we have seen lots of situations where the developers create up to 10 or 20 individual postage stamp districts with the properties to be added later to them. And what that allows is, and we've seen it in the last couple of years where homeowners are trying to get on these boards, we've seen developers on the eve of an election where homeowners are going to take the boards, remove all of the undeveloped property, even properties that are like right next to the homeowner properties from the district, and put it into another district so that they don't have to pay the bonds, they don't have to pay the taxes on it. The bonds get refinanced and everything like that, and they wind up with the homeowners bearing all of that. That's not working well. That's not the intent, what Ms. McGeady was referring to, where you have one district for one geographical area there. And the other thing I see that's not working well is I see significant amount of Metro District money for bonds, and that is not, and there are supposed to be controls on this, but the controls are not done. We have seen situations where public funds were used improperly for private benefit and were certified improperly by the supposed independent experts or engineers who are supposed to certify these funds. They're picked and chosen by the developer boards, and therefore there's been numerous examples where public funds were used improperly. The most egregious, of course, was the Landmark Towers Marin property, where millions of dollars were totally embezzled, and yet everyone signed off on this being totally appropriate. Thank you.
Great. Thank you, Brian. And I see we have Natasha, and then I also have Mary Ann and Jennifer. So we'll go in that order that you all raised your hands. So Natasha, go ahead.
Yeah, I mean, and again, there's always room for improvement. One of the things I point out, I mean, it sounds great to say that the email list, which is probably the most effective way to get to voters, is with the county, but very few voter registrations include emails. I think here where typically metro districts are designed parallel in conjunction with an HOA and the developer has access to the email list, those email lists should be shared come election time with the DEO so there can be effective communication. What's not working, in my opinion, and again, having just watched 6 districts, I believe it was, or a handful of districts adjacent to my community issue or authorize over $1 billion of authorized debt. So I think the problem of the authorization issuance of excessive debt amounts, that there should be some formula or ceilings to make sure that when the developer's done, the homeowners aren't left holding the bag, having to raise mill levy caps, having to extend debt for decades to come when these infrastructure pieces will already long have been replaced. Then there's one that I think is unfortunately not unique to our district. I think we need legislative protections. I think people underestimate how hard some developers will fight to control the district. I think when there are coercive and aggressive tactics taken against homeowners running for the board or on the board, we just had our board president stripped of all his HOA benefits and rights and banned from the developer's property. That's astounding to me. And yes, there is some criminal protection, but I think we cannot underestimate. While I would love to think that Marianne is right, that everyone's playing fairly, unfortunately, that's not what I'm seeing firsthand. We need legislative protections against this type of coercive and aggressive developer behavior. I've said it before, I'll reiterate, nobody thinks of voting in May. I would love to see the statute align elections, not just Tabor, but let's bring this to the forefront of taxpayers and voters at a time where they think of voting. And then the last and final comment is one I made previously. I agree with Brian, when there's a single district, that works great. But I think we're disenfranchising and we're allowing taxation in a lot of districts, mine included. Almost half my tax bill is to the Metro District. And we disenfranchise people if they cannot have a say in how their tax dollars are being spent or where they're being taxed. So it is the ultimate dilemma of taxation without representation. And in that same vein, the big missing piece, and it's more obvious to me in in a mountain community with second homeowners that are largely out of state. Personally, if I didn't want to serve on the board, I would have mine as part of my estate plan in a trust. A lot of people that own second properties that they're using as rental income properties on a VRBO own those in business entities. So we're disenfranchising all those property owners who are paying taxes. So I think that does have to be revisited of how can we have all those people paying their property tax bills without any voice. So those are areas I think that aren't working well, that merit closer scrutiny.
Right. And an opportunity to talk about taxation in our next session as well. So excellent. All right, Marianne, you are next.
Oh, there's so many thoughts. What is the question again? Making sure that
We are on what's not working well. We
Thank
haven't
you.
gotten yet. Yeah, we have not gotten yet to the what kind of proposals and all that. But yes.
Thank you, because I'm just processing like everyone else is. Everyone's making good points and sharing their perspectives. So I'll make sure I remember what the question is I'm trying to address. Yeah, I think what's not working well to some extent is people's understanding of what is happening with the different governance structures. And so I think having better understanding would be helpful. I think, Brian has mentioned communities that are community authority boards, suggesting that there's no transition occurring to residents based on what he cited. So what I'll do is I'll do some research on all of those and chart them up and try to identify the specific transition points and control pieces. And who should I send that to you, Sarah, so you can make it available to everybody? Or how would I do that? Because I just want to make sure we're all working with the same information. And every agreement is different and every transition point different. But to the best of my understanding, the balance in all of those authority structures is to assure that as soon as there's residents that have the ability in a community to vote, which they do pretty quickly once they move in, that they can get representation on that authority board. And so that would begin to occur not long after residents are moving in. In the long run, once the infrastructure is completed, there's a complete transition. So the number of seats that the developer nominees would have would drop back to 1. So they have the same as all the others. But that's my impression. Just like Brian speaking from his impression, I'd rather do the research, chart it up and send it out. If everybody's interested in that, I could do that.
Yes, and Marianne, for all the task force members, if there's resources that you have that would be helpful to your fellow task members, then you can certainly send that to DORA staff, and they'll make sure it is added to the resources folders within the Google Drive.
Okay, so then the other thing I would say is I think we do, what isn't working well again is that best practices. I think if we can identify some best practices and have them be legislated, then it would bridge that gap of some people doing it one way and some people doing it another way, so that the information on these governance structures is transparent to everyone.
Great, and a wonderful suggestion for improvement. So we'll revisit those in a few minutes. Thank you, Marianne. All right, Jennifer, I had you next on my list. Go ahead.
All right, thanks, Sarah. Kind of jumping onto or adding on to what Marianne had, I think consistency, there's a lack of consistency among practitioners with regard to how you set up cabs or how you operate cabs. I think for the most part, the vast majority of major players in the industry follow a similar type of order. For example, if you have a cab, you have the underlying members that comply with their statutory requirements, and then it sort of trickles up to the cab. That may not all be happening with all of the cabs. And I think maybe having some consistency there so that it does hold those who aren't doing that, either through just not thinking about it or whatever their reasoning is, that we all have that same playbook that we can follow and say, okay, yes, all cabs should be filing, these particular notices or whatnot. I think that would be very helpful. I also agree with Marianne that the understanding regarding the setup, I think, is a major bridge that needs to be gapped. I think we've seen it on our call today, even with some examples of developments that have been brought up and not understanding the story of why that structure was put into place. I'm not really sure what the solution there is, quite frankly, but I do think that once people start to hear the story as in, oh, well, this was put into place, they got 10 mils or $10 million because of X, Y, and Z for a regional infrastructure that was needed, or this district was required to upsize for X, Y, and Z purposes. I think once you hear the story behind those developments on how they came about and how the city made some decisions, how the counties made some decisions, how the structures were done, I think that helps to provide some flesh on there that gives that story a real understanding of, oh, okay, it wasn't just developers being, greedy or nefarious here, but they were actually trying to solve the riddle that was created by maybe a city desire or need, those types of things. I think that would be helpful.
Okay, well, I'll keep it to myself for now.
I think that was
just Barry, you're off of mute, just so you know.
Okay.
Okay.
All right. Sounds good. We'll see it.
I'll just continue. I think also some solutions that we've talked about in the past, and this isn't, I'm not trying to jump to the next one. We've been trying as an industry to get legislated as well. One example is the engineering cost certification that Brian had mentioned. I think you were probably referring to Amber Creek there, Brian, when you were talking about your example, and also Landmark. But and we've been trying to get some legislation on that passed and have hit some brick walls, cement walls, and every kind of wall that one can in trying to do that so that we could have it a standard of practice that most of us abide by, with having some independent third-party review of these cost certifications in order to have reimbursements done, that we have hit some of those brick walls there legislatively from a variety of different reasons. So I think that's another thing that's not working so well, is I think some of these solutions that we've been trying to get through to try to legislate some of the standards of practice to make things more uniform is really difficult going through that process. I think everybody's seen the process from one angle or the other. So those are some of the things that I think are some challenges and that aren't necessarily working well from my perspective.
Great. Thank you, Jennifer. All right. So I had Christopher, then Representative Parenti, and then Commissioner Odoricio. So Christopher, the ball is yours.
I'll be quick. I would, just like to say that a lot of what has been said as criticisms of the current system revolve around disclosures and information provided to homeowners. And I couldn't agree more with comments that have been made in terms of making sure that that kind of information gets to the homeowner, that homeowners, property owners, let me characterize them as property owners as opposed to just homeowners, that they get that. Email lists was mentioned as something that ought to be provided, and there's no good reason why that information is not given out to the community to share within the community. One thing I would like to point out in terms of costs, and Natasha had made the comment a couple times about costs. And yes, there is an upper limit on bonding authority that each district provides, but then there also is a specific list of costs that are provided by an engineer that I believe every approving entity, be it county, city, or town, reviews and approves. At least those that we work in must review and approve those to ensure that all of the costs that we're claiming are legitimate and that are in fact capable of being completed. One of the unique things that I think is a negative that I really like to share, and that is that if an initial round of bonds are issued within a community by a developer, and then it's a multi-phase project, and that before you get to the next phase, you do have a certain number of the community that becomes elected to the district board. Yet, as Mary Ann mentioned, there are a lot of additional costs necessary in order to make the next phases work. If you don't have a multiple district structure, we've certainly seen boards made up of residents that I would characterize as being perhaps not greedy, but perhaps enlightened to the fact that they can, by virtue of their control over the district at that point in time, preclude the issuance of debt sufficient to be able to accommodate the next phase, and choose to use the leverage that they have now obtained to go back and negotiate a much lower dollar volume with the developer, to the point that the subsequent phases are not going to be capable of development to the same degree and contain the same sorts of facilities that the first group did. So I think as a part of the disclosure, it'd be nice to be able to come back and say, okay, for this given project, this community, there may be multiple phases. Here's what we believe it's going to cost to develop all of it. We're going to issue bonds that facilitate the first couple of phases, but don't forget that we have additional phases that are going to come into play, and we're going to need to be able to do some things and be able to rely on the fact that this inexpensive financing that is the purpose behind districts all along is still going to be available. So I think we need to be able to look at those aspects as well.
All right, thank you, Christopher. Representative Parenti, you're next.
Thank you, Sarah. I wanted to just uplift something that Mr. Elliott just said about the multi-phase projects, and just say that as staunch a defendant of homeowners' rights as some members of the task force hear me to be, I'm really sensitive to this issue, and I'd be interested in hearing thoughts on how we attain that balance, right? Between being able to continue a project whose service development plan has been approved by the local municipality, be that city or county, and ensuring that that board, that developer board, or whatever governance structure we have in place, also cannot be used to exploit its residents as they start to move in. And I think that's really kind of the crux of a lot of the conversation when we talk about governance. I also want to say that I hear that the message about inconsistency, right? Certainly when we talk about the problems in this space, it's not an attempt to malign all of the actors in this industry, but rather to say there have been practices that really concern a lot of us, and we want to make sure that those practices end while allowing potentially, other practices that are in the best interest of their community to go forward. With all of that in mind, actually, one of the things I'm most curious about from this entire day is one of the first things that we heard about, which is here again on elector eligibility and some of those criteria that we heard about in our very first presentation. And one of the things that piqued my interest the most is this idea that all owners get to vote, all taxpayers, everyone with a tax authority, like a tax liability, if you will, get to vote. And on one hand, yes, no taxation without representation. Yes, yes, yes. And it feels like this is an area that can be exploited by dividing the ownership of a single property into 100, 200, 500 parcels. There's really no way, there's no limit to it, to allow votes to kind of get pushed into this system at the expense of people who actually live there. And I'm not sure I have an answer to that question, but I'd be really interested in hearing from other members of the task force about ways that we could balance that issue as well, alongside this other issue, sort of, protecting projects versus homeowners. And maybe Commissioner Odoricio, who's up next, might have some perspectives on that as a county commissioner. I don't know.
All right. Yes. Commissioner, please go ahead. You're going to solve all of the problems that we brought up.
Absolutely. So the things I don't think are, obviously these themes keep coming up throughout the course of this entire process of us trying to work together is transparency, participation, trust, and accountability. And I think that the things that are not working well for transparency is general understanding I think that some of the attorneys brought up the fact that we need to do a better job of understanding. I think that goes along with both governance, election, and the overall commitments, both fiscal as well as other commitments that a neighborhood would be taking on. And so we need to be able to improve transparency in a way that people truly understand what their fiscal and other obligations will be long-term. People who are buying houses do not fully understand what they're signing up for, and they're surprised when the taxes increase 1 or 2 or 3 years later at a different rate than they expected. We need to resolve that question. And if we're saying, well, we're providing enough notice, then it's just not working right now. We got to find a different way. When it comes to participation, I'm hearing from both sides that we need to address that there is destructive or distrusting participation. The builders don't trust that they can hand the keys to the kingdom to fulfill the rest of the obligations for the big picture to the residents who have an interest in trying to minimize their costs and not spend any money for new residents coming in next door. So we need to really promote more productive participation that exists, and that includes on both the residents and taxpayers as well as the builder. Trust that there's a shift of burden that both sides are concerned about. They don't trust that the others can do it. So we need to try to rebuild trust. And I think that'll happen through transparency and participation. And of course, the accountability piece. Jennifer Tanaka mentioned that there are some things in the law dealing with with accountability of election law. That I agree with that. It exists. We need to find out where that is. And then when an example was brought up earlier about certifications by fiduciaries of things that should not have been certified, I'd be interested in knowing where was the accountability there. Because I got to tell you, when I sit on a special district, I'm relying on those fiduciaries to do the right job. And I also need to be clear that those fiduciaries have a duty to whom. And we need to be very clear about what those are. And the accountability needs to go along with that to make sure that there's enough oversight and accountability. We have to define this fiduciary does not have a duty to the builder. It has it to the district, or is it to the taxpayers in the district, or to the residents and the members of the district? See where I'm going? And we need to further clarify, does that duty also extend to future taxpayers and residents? So those are some of the things that I think we could do better.
All right, thank you, Commissioner. So I have a couple more hands that are raised, and we have kind of bled into some solutions mode here, which is wonderful. So and we've already heard quite a bit around best practices and consistency and some statements around disclosure. And I think, Commissioner, you summarized that up very, very well. So we're going to go to Mary Ann and to Jennifer, but I did promise your task force chair that I would give her a couple minutes before we wrapped up the call to just go over a few administrative questions. So so we'll try to be brief, but Mary Ann, please go right ahead.
Oh gosh, be brief is always so difficult in this circumstance. I agree with Jennifer about the cost certification. I think that's an important piece here. I know Brian referenced Marin. I would note in Marin, all the bond proceeds were distributed, as I understand the facts, without any cost certification being done. And then when a cost certification was done so that the district accountant could code the costs, my understanding is that the cost verifier was given a limited scope. So it's not the normal scope that someone is given who's an engineer in that circumstance. So Marin is not an example of how cost certification is done. So coming back to the trust and the accountability piece, God, there were so many things here. I don't know. I'm going back on my notes because I keep writing notes to myself. Goodness, one thing I want to say well, it's really a solution question. If we're going to solutions, I'll stop talking.
We are talking about solutions. So
okay.
Yes.
Okay. The challenge on the email distribution list from that a CAB or a district might have in its wearing its covenant enforcement hat versus or its HOA companion is that the private list can't be used for public purposes. So to legislate that, we'll have to be real. If that's something that we want to do, we're going to have to be real careful about how to draft that because right now when our DEOs ask HOAs to get email lists for any reason, we're always told no, we can't get those because it's private. When you are in an HOA and you give your email account to the HOA person, you're not giving it to them to use that list for all kinds of purposes. So I think it's a good idea, Natasha. I'm just saying we have to figure out with maybe some HOA lawyers how to do that. Yes, and then other solutions, I think it had been mentioned in a prior meeting that perhaps authority structures were being used to sidestep the guardrails that are in there for districts. I don't believe that's true. I don't think the intent is to sidestep. And I also believe that all the districts that are members, their powers, authorities, and limitations on those flow up to that authority. It can't have more power than any of its member entities. The other thing is about the management district and taxing districts, as Brian was saying, how do you have this little district and how does that make sense? Because in the service plans where they're all approved, they're approved to take care of the same services together and to enter into agreements to sort out how they do that within the guardrails that every service plan has. So I think that, again, this is a space that we could do some best practices legislation in so that we have more consistency so people understand it better. And that we have clarity that there is no sidestep on what the district limitations are when you're a member of an authority.
Thank you, Mary Ann. And Jennifer, I saw you had your hand up, and again, we're talking some solutions now.
Right. So I just wanted to dovetail into what Commissioner O'Dorisio had talked about with the engineering certification. I think in that instance, the fiduciary duty has to be to the district who is engaging that particular entity, but the district in turn has a fiduciary duty to all of its residents in order to act in the best so the board has a fiduciary duty to act in the best interest of the district and its constituents. So I think it does flow through. I think it's similar to what maybe our municipal advisor language is, which we had enacted last year, which really puts that fiduciary, there's already a fiduciary duty from the municipal advisor to the district, as opposed to anybody who sits on the district board, any individual. It's strictly to the district. So I think it would have to be the same here. Obviously, it cannot go to any of the private persons that are involved in the transaction. It has to really be to ultimately those that are intended to be protected by that cost certification at the end of the day, which are the residents, property owners, taxpayers, which are represented by that district board. So to me, I feel like that is something that I would love to explore. We certainly beat that horse to death in the past couple of years trying to get that through. I would love to see something like that come through. And then I also agree with Marianne that having some best practices codified for Title 29 authorities that are created will help to, I think, take away the perception that they're trying to skirt some of these laws that the member districts have. I likewise don't think that that is the intent, but I feel like we can certainly have some legislation that's probably pretty quick to pull all them under those same websites, those types of things that can ensure that you have information out there and some best practices in place for the authorities as well. So I know we're running out of time, so I'm going to stop talking.
Yes, that's fine. That's fine. So just a quick check on everyone, because we are at time, and I just wanted to just ask our task force chair if we could go a few minutes over to make sure that we have an opportunity to really talk about solutions. I think it might be difficult to bring this topic forward into the next meeting because we'll forget everything that we've just been talking about. Is that all right, Marcia?
Absolutely.
All right. Understanding some folks might have to sign off, but I also want to, acknowledge what Representative Parenti said as well about not wanting to cut the conversation short. Particularly if there's some very productive solutions that are still here in this group that we can still bring to the surface. So Brian, I saw your hand up next.
Oh, thank you. I have a few solutions here. First of all, I think one of the solutions, actually, I'm going to address Representative Parenti's concern over one piece of property being divided into multiple, like 100. There's already a partial solution for that the legislature has already adopted in 32-1-808 that limits the number of contracts to purchase property or transfers of property. So you can't do more than 11. But the problem is, one of the solutions would be, I think there was some alluding to it. Once there are homeowners that are qualified qualified electors that are sufficient and willing to be on the board, I think those directors that originally qualified because there were no individuals able to be on the board should be required to step down and be replaced with homeowners that are able, willing, and eligible electors without resort to these types of contracts. Second, the concern about the management districts being as small as 10 feet by 10 feet, there needs to be some type of enforcement of an existing statute, CRS 32-1-203, which specifically says that for each district created, you have to demonstrate that all the statutory criteria are met, such as that there is a requirement for a need for services, an ability to finance the services, and each district needs to be evaluated separately to do that. Third, I think one of the concerns about transparency is that if a homeowner purchases in a metro district under an existing service plan, and they're believing that there's going to be a certain amount of area in that, and then what happens is the developer on the eve of homeowner election pulls out 80 or 90% of the property, what the homeowners thought they were buying into is no longer the case. Now there's many fewer homes that have to pay for the costs and the debt of this metro district. That needs to be prevented. And I think the solution should be that even if you have a multi-phase project, one geographic area must be for one metro district. You can't be shifting properties back and forth between those districts Or if there is any significant shifting, I could see 5 or 10% of the properties, but certainly you don't want 90% of the properties be pulled out of a district where a few homeowners have already purchased. And finally, I think there needs to be some oversight as a solution, an oversight over these unfair authority board agreements. I just don't see any excuse whatsoever for there to be an authority board in which the developer district gets 7 votes and the homeowner district gets 1 vote. Thank you.
Thanks, Brian. I appreciate that. All right, Commissioner O'Dorisio, I have you next.
All right, I'll try to be brief. Normally, I don't like to start with the negatives, but I'm going to tell you what I don't think are good. What I don't think we should be doing is, I know Natasha had mentioned earlier about this bias about conflicts of interest, I guess, between the cities and counties, somehow like profiting or making money from these. I'm not aware of that. What I am aware of is that a lot of what metro districts do is they fill in the gaps for things on a smaller basis, on a project basis, that the cities and counties don't have the resources to do on their own, as well as we get a lot of pressure from a lot of folks to say, let development pay its way. And so that this is an example where metro districts are extremely important to cities and counties, not because we're making any money or kickbacks, but because they're filling in the gaps where growth exists. And we don't always have the ability to identify where the next curbs, gutters, and sidewalks and roads and bridges should be. And so a lot of times in this environment, we let that come to us and let those developments work, propose those horizontal infrastructures. And so I just want to make sure that also goes to something that somebody else mentioned, is that to have, I think it was Representative Parenti, we can't just shift the governance of hundreds and hundreds of these metro districts onto cities and counties. If you sit on some of the cities and counties and you see how challenging it is just to simply bring in a couple urban renewal districts for governance, if you have cities and counties now taking on dozens or hundreds of new governance structures, it's going to be impossible. So just to shift the burden to have cities and counties take that over. Now you can have them look at different types of improvement districts, but that should be on a one-off basis for the cities and counties to make the choice on their own. I would hate for us to simply say that we need to now shift the burden of all governance onto the local governments. And I could tell you now that part of the challenge that we're having is that local governments feel like there's a lot of shifting the burden onto local governments, taking away a lot of our authority, taking away a lot of our resources, while also just jamming us with more responsibilities, liabilities, and things to do. Simply put, we're being asked to do a lot more with less. And so I would ask that we make sure that's not on the table, to shift that over. And those are some of the, and like I said, I hate to lead with the negatives, but these are some things I want us to consider as we start putting together some of our solutions. At the end of the day, our solutions are going to come down to, how do we merge the interests? How do we merge the interests of the people that are moving into these neighborhoods with the people that are building these neighborhoods? And until you can find a way for us to productively merge the interests, there's going to be conflict. And so we need to be able to find a way to say, do you want to live in a community that finishes the project? Do you want to live in a community that has a high level of quality of life? If so, here's what it's going to cost, and here are the obligations you're going to take on by moving into this community. And we need to be more clear about that.
Thank you, Commissioner. All right, and I see Marianne is next, and then I see Natasha's hand as well. So Marianne, please go ahead.
Okay, I will try. So on the solutions mentioned, one was to suggest that an interpretation of the statute about the boundaries should be, these are the boundaries of the district, and these are the improvements that this district 1 would do, and then this district 2 would do, and this district 3 would do. And that works for a 200 unit residential unit community, but it doesn't work for a master plan community, because the development, the phasing, the platting, it happens over time. And the extreme example that I was providing with 4,000 acres, that's a project that could take 12, 15 years to process through to full development. And so there's just no way to identify those boundaries in the beginning, but you do have an idea of the order of magnitude. You do come up with what is a reasonable and rational approach, and then properties are included as the plats are approved. And so I just don't think changing the statute is going to result in what the state needs right now, which is as many housing units built and as many price points as we possibly can encourage so that there's more accessibility to housing. The next comment about the boundaries that was suggested, I don't understand because it says property boundaries, there shouldn't be allowed to be exclusions. Once a district has issued debt, the state statutes require that the burden for repayment of the debt carry with that property when it's excluded. So the county assessor creates a map, and whatever debt's outstanding when that property is excluded, it continues to be taxed for that debt, and it continues to be taxed for refinancing of that debt. So to suggest that property is excluded and therefore not paying for the debt doesn't make any sense to me. And so I don't think we need a solution for that. I think that's already in the statutes. There was also a limit on once there's home sales and qualified residents who are willing to serve, that the developer representatives should be obligated to step down. There's a lot of good reasons to not do that, and I think we've already talked about the need to complete the project. And I'm not saying if a district has a resident who comes forward and is running during an election process or running during a recall process, that process is already in the statutes and they will already get on a board. But to requires a board of developer representatives to have to vacate their positions in the middle of a term without a recall or without an election cycle doesn't make sense. Let's see, the oversight on the authority boards, again, I think trying to work through what are statutory provisions that are consistent in how authorities function, I think is the best course there. And so I will go ahead again and put the chart together that refers to the communities. I guess I'll have to get the tape, go back to the recording because I didn't try and get all those down, unless you want to email them to somebody who could send them to me, because I know we can't communicate between and amongst ourselves. But I would like to get that voting references up in a chart for everybody to see, because I don't think it is not the case that any of these entities have one vote for anybody but the developer nominee, which is the way it's being described. So I don't think that's a problem we need to solve. I think it's something we need to understand. Thank you.
All right, thank you, Marianne. All right, Natasha, you are next. And you might be our last comment. So
great. And I've already made some of them solutions. And I think
all right.
Commissioner Doricio hit it on the head that, we do have to merge the interests. We need the developments to be successful on the flip side without the downside. And that does require some caps and some protections. I would take Mr. Matisse's comment one step further and say, I like single. I don't like this tiered structure. I think it's very artificial and it really disenfranchises the homeowners. I think homeowners get that they want the development built out. That being said, I also stand by my earlier comment. Most Americans don't think of voting in May. I think getting participation in homeowner involvement will require eventually revisiting this statutory setup of Title 32 and moving elections to a time in November when most people think of voting. As living in a district right now that's seeing it firsthand, I think we absolutely need some legislative protections that have teeth, both criminally and civilly, when there are abuses where developers are trying to artificially control or intimidate. We had a director who resigned after one meeting. This can't stand and this can't happen. This was a validly elected director. I like the idea of best practices. My final comment is there needs to be a cap, some formula. When a district with a couple hundred homes has authorized debt of $1 billion, I represent developers in metro districts. Infrastructure is expensive, but there needs to be some formulaic cap so that, that protection that Commissioner Doricio referenced of how do we merge the interests. When you have a developer control board in the beginning who can write and authorize the blank check. So what can be authorized and what can be issued needs to be capped, in my opinion. So those would be my thoughts.
All right, so I see I have Jennifer's hand raised. Do you have a brief comment, Jennifer? Hopefully.
Super brief. I was just going to note for Natasha too, the service plan, especially now after legislation last year, there is required to be a debt limit cap that's put into service plans. So quite frankly, regardless of what is in the Tabor authorizations, you are limited by that service plan. And that is a new add that came with the legislation last year. That also includes a debt service mill levy cap as well. So I think that's at least helpful to go in that direction. That might add some comfort there.
Yeah, the reality is it looks good on paper, Jennifer, but when you have town and county commissions that don't have a good understanding and have always deferred to the Metro District, unfortunately, again, that goes back to Commissioner O'Dorisio's of building that trust and transparency.
Yeah, other than I will counter that it is a legal document that is bound to be followed by the district. So unless there is a service plan amendment, you cannot exceed that amount without having a violation. And I can tell you as a general counsel has to write an opinion when you issue bonds as to compliance with the service plan. My firm would be the first sued in that, along with bond counsel and a lot of other people if you were to exceed that. But so I don't know if there are people out there that are exceeding that. If so, then that is a major no, but there are debt limits in there that do have to be complied with in order to issue the debt. So I know that we're running out of time. Happy to talk about that more because I would like to hear a little bit more of that perspective too from you, Natasha.
All right, thank you. Thank you very much, Jennifer. I appreciate you ending us on a constructive note. All right, so I'm going to turn this over to our chair, Marcia Waters. Marcia, I know you had a couple of questions for the task force members.
So task force members, I just wanted to gauge kind of what your expectations are as far as the subject matter experts that Pip and Sarah find for your meetings. We've gotten some criticisms about, well, it looks like they're all from the industry, although I think they've been trying to find people that have had professional experience dealing with metro districts. And I have heard, like at your last meeting, you said you wanted more kind of the public perspective. When dealing with the public perspective, what are your expectations about what they are going to present to you versus hiring somebody that's got 20 years in dealing with a certain area? Please don't all speak at once.
So Marcia, you're just seeking some clarification around those expectations around
Exactly.
around content, who delivers the content, what the objectives are, and how we can best meet that.
And bear in mind, we are doing a public comment session, your 6th meeting. So kind of the personal stories about metro districts, that would be the appropriate time for those types of stories. But really just your thoughts on what you're expecting to hear from kind of more of the public perspective in dealing with the different issues that you guys are tasked with discussing for 1105.
Yes, Natasha, go ahead.
Let me jump in. I mean, as was said at the last meeting, this is the Homeowner Metro District Task Force. We may think that our collective knowledge that we are identifying the correct issues. I do think that feedback in that meeting with homeowners, I don't think any of us, no matter how many years of experience we have, should take away their voice. We want to hear their concerns and make sure we've addressed the issues within the scope of this charter of the task force. I do think we want to have a good balance, that if we're going to have a speaker, that we also offset, let's say on management companies. Let's have a management company that only represents homeowner controlled districts and one that represents firms that represent developer controlled districts. So I think that balance would help the dialogue, and it would help us. I mean, I've really welcomed some of the new ideas that were newer to me and the perspectives. So a little more balance, I think, would be helpful.
Okay.
Other comments or suggestions from other task force members? Yes, Representative Parenti, please go ahead.
Thank you. Maybe just an observation, which is that today we had like a really robust dialogue and debate. And I think having the two, not two sides, because I don't think there were necessarily two sides, but having different perspectives on the same issue was really helpful and really helped spark that conversation. And so I would just encourage more of that. Yeah.
Okay, that's very helpful. Sarah, that's all I had.
Okay, great. Great. Well, I'm going to forego, since we are running late, I am going to just forego sharing my screen, but just remind everyone that our next meeting is going to be on February 5th. That is on tax levying practices, authority and practices. Our final meeting is going to be February 26th. That has been moved 1 week out. That is going to be our public comment period, and we will be building in time for task force reflection and discussion as part of that meeting. Both of those are going to be held from 2 to 4. And then our final meeting is going to be on April 22nd, and that is when we will be reviewing the HOA task force and their final report. My guess is for the 5th, we will probably build in some time at the beginning to reflect on the HOA task force legislative recommendations. So we'll work with the agenda to hopefully structure that, so we still have plenty of time for discussion on tax levying, but we do want to make sure that we're covering those HOA recommendations as early as we can so that they can have value for the legislative session this year. So with that, we can go ahead and wrap up our call. I appreciate everyone staying on a little later for this call, but I think we had a number of really great suggestions that we'll be able to document in the report. So thank you, everyone, and have a wonderful evening.